Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in the Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Leroy Batiste and Senator Sophia Choate, SC, both of whom are out of the country, and to Senator Foster Cummings, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency, the President, Christine Carla Kangaloo, ORTT. By Her Excellency, Christine Carla Kangaloo, ORTT, the President of the Republic of Trinidad and Tobago, and the Commander-in-Chief of the Armed Forces. To Mr. Andrew Ramsubik, whereas Senator the Honorable Leroy Batiste is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President, as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Andrew Ramsubik, to be a member of the Senate temporarily with effect from the 10th of February and continuing during the absence of Senator the Honorable Leroy Batiste from Trinidad and Tobago, given under the hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, on this 10th day of February 2026. To Mr. Farai, Hove, Masaisai. Whereas Senator Foster Cummings is incapable of performing his duties as a senator by reason of illness, now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Farai, Hove, Masaisai, to be a member of the Senate temporarily with effect from the 10th of February 2026 and continuing during the absence of Senator Foster Cummings by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, on this 10th day of February 2026. To Ms. Zola Phillips. Whereas Senator Sophia Choate, SC, is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of this power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola Phillips, to be a member of the Senate temporarily with effect from the 10th of February 2026 and continuing during the absence of Senator Sophia Choate, SC, from Trinidad and Tobago. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 9th day of February 2026. Honorable Senators, Senators are required to take the oath. Can we all stand?
I, Andrew Ramswick, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter. I, Farai, Hove, Masaisai, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Zola Phillips, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Public business, government business, motions.
The Minister of Land and Legal Affairs.
Good morning, Mr. President. Mr. President, I beg to move the following motion standing in my name. Whereas it is provided by Section 5(1) of the Land Acquisition Act, Chapter 5801, that the President may by order declare that land is required for public purpose. And whereas it is provided by Section 5(2) of the Act, that Parliament may by resolution approve an order made under Section 5(1). And whereas the Land Acquisition Requisition Order 2025 was made by the President under Section 5(1) of the Act as legal notice, number 24, dated the 2nd day of February 2026. And whereas it is expedient to approve the said order, be it resolved that the Land Acquisition Requisition Order 2026 be approved. Mr. President, again, it is a pleasure to join my distinguished colleagues in this honorable chamber. I didn't know I would be returning so soon, but we are here again in order to bring to this Senate's attention another parcel of land that is required at its last stage of acquisition for public purpose. And Mr. President, if you would allow me to just go through the 3 stages of the acquisition process that would have allowed us to get to this particular point. Under the Land Acquisition Act, Section 3 of the Act requires that once a state wants a particular parcel of land for a public purpose, a Section 3 notice must be published giving a notice to the world that the state wants this particular piece of property or land for a public purpose. In this case, the public purpose was for the Trinidad and Tobago Housing Development Corporation for the construction of homes. So, Cabinet would have agreed to this in 2019, and the Section 3 notice was published on the 24th of January, 2020. So notice was given to the entire world that the state required this parcel of land off Cora, Royal Road, and El Dorado for housing development. Once that was finished, Mr. President, and all of the steps and notices were published and so on, we now move to the Section 4 notice. The Section 4 notice then says, okay, you have told the world that you want this particular property for a public purpose. Now, the Commissioner of State Lands, under the Act, is empowered to take possession of the property. So, once the Section 4 notice is published, the Commissioner can go and take physical occupation or possession of the lands. When the Section 4 notice is published, the Commissioner must do this within 6 months by law. If the Commissioner fails to take possession within the 6 months, what happens according to Section 4, subsection 4 of the Act? It says that if the Commissioner fails to take possession of the land within 6 months of the publication of an order issued under subsection 1, this is the Section 4 order now, the said order lapses and the powers of the Commissioner thereupon ceases to have any effect. And Mr. President, the reason I raise this is because this happened in this particular case. The Section 4 notice was initially published on the 30th of April 2020. And this legal notice was number 84 of 2020. But what happened, Mr. President, is that the Commissioner of State Lands would not or did not take possession of the lands within that 6-month period. So therefore, the April order lapsed. So therefore, a new order had to be published, and this was published by legal notice number 355, dated the 13th of November, 2020. So thereafter, when the new Section 4 notice was published, possession was actually taken of the lands. Thereafter, the Housing Development Corporation, the HDC, would have engaged contractors and so on, and currently standing on that land, Mr. President, is 100 townhouse units, and this is information I would have received through the Ministry of Housing, and those units at this particular site cannot be distributed, notwithstanding I'm told that there was a hurried allocation process prior to the general election. The deeds of leases cannot be issued simply because the state does not have title for the lands. So what we are doing here, Mr. President, is now engaging the third step, which is the Section 5 notice. And under Section 5 of the Land Acquisition Act, it now requires us to go to Cabinet, indicate that 3 and 4 has been finished, the Section 5 has to be done, we have the survey plans that have been approved, the Section 5.1 notice would have been published, and now that matter has to engage the attention of the Parliament. This matter was dealt with and passed in the other place. Surprisingly, we got support from the opposition. I hope that a similar position will be adopted here this morning, Mr. President, where we will get the necessary support. Simply because the HDC, Mr. President, is ready for the distribution process. But they cannot, as I said, process the deeds of lease because there is no root title. The HDC does not own the lands, notwithstanding that they have built upon the lands. And this is something that we have been identifying, Mr. President, in the ministry, where several state projects and government projects are in the stage of execution, close to completion and so on. And the state does not have that formalized title for the lands. And that is what brought us here today, Mr. President, because we want to ensure that those houses can, in fact, be distributed. So, Mr. President, one may wonder why or what or who is the owner of this land. And the land, just for the record, comprises 11.94 acres, more or less situate off Cora Royal Road, El Dorado, in the ward of Tacarigua, in the county of St. George, and described in the schedule of the survey plan signed by the Director of Surveys dated the 12th of February 2025. And Mr. President, in the notice that was published, the 2026 notice was published on the 2nd of February 2026 by legal notice number 24. This was done this year, Mr. President, in terms of giving notice that we are going to now formally acquire title or vest the lands into the state. So that was the Section 5.1 notice that was published, and that is before the attention of this particular chamber. Mr. President, the owner of the land is no secret. According to the notice that was published, the lands now formally belong to TMV Limited. Who is TMV Limited? My friend Senator Dhanpaul will be very familiar, coming from the Ministry of Finance. These were assets that were acquired through the CL Financial matters, Mr. President. Cabinet in 2019 took a decision where they would have requested from the HCL what is their land bank, and the HCL would have identified approximately 3,000 acres of lands that were earmarked for housing. And I will give you the list, Mr. President. 12.26 acres in Bonaire Gardens, Aruca, 1,013 acres in El Dorado Estate off Cora Road, El Dorado, 11.94 acres off Cora Royal Road, El Dorado, that's what we're dealing with now, 40.5 acres in El Toco Estate, Toco, 112.34 acres in Santa Rosa Industrial Estate, south of the Churchill Roosevelt Highway in Arima, 80.73 acres in Tumpuna Road, south of the Churchill Roosevelt Highway, Arima, and 146.93 acres in the Buku Estate in Tobago. So this parcel of land that we're dealing with here, Mr. President, forms part of that land bank that came out of the CL Financial matters. Now, Mr. President, I just want to indicate to the House the complexity of this procedure that we're dealing with here. Land acquisition is never an easy thing. There are political, social, and economic considerations. More so, a lot of processes that take place. There's a particular paper I want to just bring to the attention of this House that was done by the University of the... It was done through the Ministry of Food Production, Land and Marine Affairs, Land Management Division, and this paper is from Esric Huggins, Karen Roach, and Jeremie. Land acquisition in the context of institutional problems in the legal and administrative framework in Trinidad and Tobago. And according to this particular paper, Mr. President, they set out 3 process flowcharts for the sections 3, 4, and 5 notices that I would have explained to the House. Mr. President, those 3 processes, when taken together, amounts to 39 stages. So you can understand the level of bureaucracy for us to get to this stage. 39. In the Section 3 notice, just to say that you have intention to acquire the lands, there are 20 stages. The Section 3, there are 5 stages, 5 steps. And when we get to the Section 5, there are 14 steps. So after we finish here, after the 2 houses would have considered this, approved the order, it still now has to go and get another legal notice prepared. It has to go and publish, goes back to the Commission of State Lands, goes in the GIS units, notices are served to the owners in the warden's offices, the Registrar General, and in the newspaper. It's a completely transparent process, Mr. President, but it's a lengthy, cumbersome process. And in the paper, it outlined that. It outlined that there are duplications and so on. And the paper asks, and I am quoting, it says, why is there the need to go to Cabinet 2 or 3 times in some instances for each of the sections 3, 4, and 5 notices? Why is Parliament consulted only at the end of the process? Why does a legal notice have to be manually reviewed by the CPC, then the Commission of State Lands, and back to the CPC before its publication? And there are some administrative and other issues which add to the time to the closure of a land acquisition process. So, Mr. President, it's no easy feat. However, I can tell you that this matter is engaging the attention of the Ministry of Land and Legal Affairs. In a very short time, we were able to engage both houses of Parliament and brought 2 successful land acquisition orders. The first we would have brought was with the Tobago estate that was languishing for many, many years, over many governments also. And that matter has in fact been dealt with, and I thank my colleagues in this honorable chamber for giving the support for that particular order. We are here now to deal with a matter of housing. The houses are already built. The lands now have to be formally vested in the state, so title can pass to the landowners. So, Mr. President, this is not a very complex matter. Senator Dhanpaul warned me and told me, he said, do not say this is a non-contentious matter, because the last time I said that, it became a bit heated. But I hope we can measure the temperature in this particular place this morning, Mr. President, all the way in the bacchanal season. And I thank you very much for allowing me to engage the attention of your honorable House, and I beg to move.
Honorable Senators, I will now propose the question for debate. The question is, whereas it is provided by Section 5, subsection 1 of the Land Acquisition Act, Chapter 5801, hereinafter referred to as the Act, that the President may, by order, declare that land is required for a public purpose. And whereas it is provided by Section 5, subsection 2 of the Act, that Parliament may, by resolution, approve an order made under Section 5, subsection 1. And whereas the Land Acquisition Requisition Order 2025 was made by the President under Section 5, subsection 1 of the Act as legal notice number 24, dated the 2nd day of February 2026. And whereas it is expedient to approve the said order, be it resolved that the Land Acquisition Requisition Order 2026 be approved. Senator Vishnu, Dhanpaul.
Thank you very much, Mr. President, and good morning. And as usual, nice to see you again. Mr. President, I'll be brief, especially given the fact that my colleague, Minister Hosein, has agreed that the debate should be non-contentious. Mr. President, this motion seeks approval for a land acquisition order under the Trinidad and Tobago Land Acquisition Act, Chapter 5801. Section 5.1 of the Land Acquisition Act authorizes the President to declare that the land is required for a public purpose. Section 5.2 requires parliamentary approval of such orders by resolution. The mover of the motion, Minister Hosein, as far as I'm aware, is asking this Honourable House to approve this requisition order. Mr. President, in 3 legal notices published in a daily newspaper on November 19, 2020, the then government stated that the Commissioner of State Lands is authorized to take possession of the parcels of land comprising 104.93 acres of land along the East-West Corridor. One of the parcels was 11.94 acres of land located off Coral Road in El Dorado, said to belong to TMV Limited, a subsidiary of CL Financial. The 3 parcels of land were all subject to an order made by the then President, Paul Weeks, directed by the Cabinet, and were acquired under Section 4.1 of the Land Acquisition Act. Mr. President, it should be noted that the initial plan of the government at the time was to acquire the land through private treaty, but there were several arguments about the valuation of the land, so it delayed the process. And so the initial plan was private treaty and not necessarily compulsory acquisition. This section of the law, that is Section 4.1, allows the President, if satisfied that the circumstances of the case justify such action, to issue an order authorizing the Commissioner of State Lands, without waiting for the formal vesting of the land in the state, under Section 5, to take possession of the land and apply it for any purpose connected with the use to which it is intended to be put on acquisition. In this case, it will be to develop affordable housing. Mr. President, legal notice number 24, dated February 2nd, 2026, identifies the exact parcel of land of approximately 11.94 acres situate off Coral Road in El Dorado. Mr. President, one of the main reasons for the vesting delay was a significant difference in the valuation of the land computed by the Commissioner of Valuations. The negotiations were protracted in trying to arrive at a mutually beneficial cost. Mr. President, on March 19, 2024, the then PNM government turned the sod on the said land, and by December 2025, 100 townhouses were constructed. These were constructed as affordable homes for low and middle income families. The estimated price per unit stood at between $950,000 and $1.1 million. Mr. President, several individuals who met the initial criteria were interviewed. The 100 townhouses have already been allocated through letters of offer. Mr. President, these individuals with letters of offer would now have legitimate expectations that the offers will be honored. However, Mr. President, we on this side have been informed that these letters of offer have now been voided, and maybe the minister could explain in his wrapping up. Mr. President, we have also been informed that the initial offer prices for the 100 townhouses have been increased exponentially. This is a disturbing pattern which has been emerging. And by example, Mr. President, I have with me a letter from the HEC to a potential homeowner, and the subject is notification of purchase price increase for building X, I'm not saying the name of the building, Unit Y, Carson Fields Housing Development, Phase 3, Shogunas, sorry. The Trinidad Housing
President,
Development
46,
Corporation,
one.
Asset Management Company Limited.
46, we were not in Carson Field, we in Cora.
Hold that. Let us stick to what we are dealing with, right? We are not going to Carson Field. If you want to focus on Cora in terms of the unit, you would be in order. Please.
Thank you, Mr. President, for the guidance. What I'm trying to do, Mr. President, is simple. I'm trying to draw a parallel between the land acquisition in Cora and what transpired at Carson Field and the purchase prices accordingly. It's just a parallel I'm trying to arrive at. So with your leave. The Trinidad Housing Development Corporation, Asset Management Company Limited, refers to the caption matter and to the existing agreement for sale in respect of Building X, Unit Y, Castlefield's housing development. The corporation wishes to advise that pursuant to the board decision dated January 12, 2026, the purchase price for the above-mentioned unit has been revised. The purchase price has increased from $575,000.00 to $750,000.00, an increase of $175,000, Mr. President. The revised purchase price and the terms outlined herein are subject to strict compliance with the terms and conditions of the subsisting agreement for sale dated July 8, 2025, save and except for the variation of the purchase price as aforementioned. Mr. President, in reality, this transaction does not really represent compulsory acquisition in the traditional sense, since the state already owns approximately 30% of HCL through CL Financial. CL Financial is in liquidation with court-appointed liquidators, Grant Thornton. Mr. President, the court in Trinidad and Tobago must approve the sale of each asset by the liquidator. In other words, there can be no fire sale, as has been mentioned and bandied about. Mr. President, it is common knowledge that the CL Financial bailout cost the taxpayers of this country $25 billion plus. Mr. President, we support this motion, since the transaction will help to recover public funds lost in the collapse. The taxpayers-funded bailout should benefit from asset recovery. Mr. President, I have absolutely no sympathy for the hierarchy of CL Financial. I have sympathy, all my sympathy will be for the taxpayers of Trinidad and Tobago. Thank you very much, Mr.
Of Land and Legal Affairs.
Thank you very much, Mr. President, and I wish to just respond to a couple of matters that were placed on record. Mr. President, with respect to the increase in prices of homes and so on, when this matter engaged the attention of the other place, the Minister of Housing indicated very clearly to the entire country that the prices of these units have not changed. The Honorable Senator said that letters of offers were voided and so on. Those are matters, I think, Mr. President, that my friend is trying to score some political points. I don't think it took him any further. These houses will be allocated in a fair, transparent, and equitable manner. And the last point that the Honorable Senator raised was that this is not really a land acquisition, because we're going to really set off what CL Financial owes the government. But, Mr. President, they could not have done it in 10 years. It takes a UNC government to come now and do it. And I think there's an issue my friend raised with respect to negotiations and so on would have delayed the acquisition. If one examines the law in great detail, in particular the Land Acquisition Act, you would realize that you can vest the lands in the state, notwithstanding that the compensation issue has not been settled, because the owners within the Act itself have a remedy, which is the interest rate that accrues from the date of possession. So that really should not be an excuse for incompetence in terms of the delay of this procedure. We are moving with alacrity, Mr. President. We are moving responsible. We are moving expeditious. We are getting it done. And I thank you very much, Mr. President, and I beg to move.
Honorable Senators, the question is, be it resolved that the Land Acquisition Requisition Order 2026 be approved. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The motion is carried.
Bill second reading.
The Honorable Attorney General.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary to be known as the Civil Division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Court, to make jurisdiction for estates administration business exercisable in a subdivision of the Civil Division known as the Estates Administration Office, and for related matters be now read a second time. Mr. President, the bill before the Senate this morning is a piece of legislation which is the end product of extensive research conducted by the judiciary to guide the development of a legislative framework. The judiciary submitted a bill to Cabinet a year or some ago, the Civil Division Bill 2024, which was passed in the House, but lapsed upon dissolution of the 12th Parliament on March the 18th, 2025. The bill before us follows similar legislation establishing divisions of the Supreme Court, namely the Family and Children Division Act of 2016, the Criminal Division and District Criminal and Traffic Courts Act of 2018. And, Mr. President, if I might be allowed, I had the privilege in starting the Family Court pilot project, as it then was, in 2005. And that, I think, is one of the things that I have done in public life, which I am extremely proud of. The judiciary does not have a seat at the table in Westminster, and they do not have a seat at the table in our Parliament. The arms of the state are separate. As a legislature, we respect the work of those who must interpret the laws which we enact. And they, the judiciary, gives deference, a margin of appreciation greater in the years since Surat and Suraj, to the laws which we enact. Their role in this piece of legislation cannot be overstated. The Civil Division which they propose is to be created formally by statute with a civil court, a small claims court, and the Estates Administration Office. The staffing structure of the division and its subdivisions have, in the main, included staffing positions from among those already within the judiciary, and very little further adjustment is required. This government recognizes the valuable work done by the judiciary in bringing this legislation. It is best poised to understand and to propose solutions to the challenges faced by the courts in terms of backlogs and bottlenecks which lead to lengthy delays in the administration of justice. If there's a backlog in the civil division, there will be, given the structure of our courts and the manpower that runs the court, a corresponding backlog in the criminal justice system. This government, Mr. President, is deeply concerned about improving the efficiency of the courts in this country, as is evident by our establishment of a separate Ministry of Justice. As I stated just a few days ago at a stakeholder meeting hosted by the judiciary, justice delayed is intolerable. And this applies to all matters before the courts, criminal, civil, and otherwise. Delay produces systemic damage. In the criminal sphere, it weakens deterrence. It creates the perception that offenses are not punishable. On the civil side, delays over time foster impunity, erodes respect for the rule of law, and when justice takes years to arrive, people take justice into their own hands. Public confidence is diminished, and with it, the authority of the justice system itself is brought into question. I've said it before, the absence of law yields a state of anarchy. As the Prime Minister has said time and time again, this government has a zero-tolerance approach to lawlessness. And treating with lawlessness must be a multi-pronged approach which involves addressing legislation to ensure that the judicial system operates efficiently and that justice is delivered in a more timely manner. The legislation before us is a critical piece of the puzzle. We are tending to the different elements that make for a more secure society and one in which citizens have confidence in the rule of law. The purposes of the bill, as reflected in the long title, are to restructure and to modernize the administration of civil justice in Trinidad and Tobago by creating a dedicated civil division of the judiciary and clearly allocating jurisdiction among specialized courts and offices. In particular, the bill aims to A, establish a civil division of the judiciary comprising the civil court, a small claims court, and the estates administration office. B, to transfer and to consolidate civil jurisdiction formerly exercised by the High Court, the petty civil courts, and the summary courts into clearly defined forums, improving efficiency and case management. C, to create a civil court as a specialist court with the same authority and jurisdiction as the High Court in civil matters, including the power to hear election petitions. That, I suppose, is a relic of the Gypsy and Chaitan case, in which there were interlocutory proceedings dealing with the absence of election rules, and the question arose, is the High Court an election court, and so on. That is expressly provided for in this piece of legislation. D, to establish a small claims court to handle low-value civil disputes more quickly and accessibly, replacing the petty civil courts and expanding procedural flexibility, including mediation and electronic hearings. E, to create a dedicated estates administration office to manage the difficulties which we now have. The situation has been improving, but we still have a problem with probate and estate administration matters. And F, to provide a more modern administrative framework for staffing, management, record-keeping, digital systems, and court operations within the civil division. I take small claims first. The judiciary prepared a small claims court concept document in 2021, which considered the adoption of specialized small claims courts in Singapore, the European Union, the United Kingdom, Canadian provinces of British Columbia, Manitoba, and Ontario. It should be noted that the position paper comes against a backdrop, and the backdrop is this. Our existing law, contained in the Petty Civil Courts Act, Chapter 421, was enacted in 1911, and it forms part of the summary courts. The Petty Civil Courts form part of the summary courts, with their jurisdiction being limited to civil matters involving sums of less than $50,000. The types of matters that come before the Petty Civil Courts include debt, damages, that debt would be money owing, damages, breach of contract, negligence, recovery of land. A review of the Petty Civil Court statistical reports by the judiciary in May of 2020 revealed the following. 1, the average time to disposition is 2 years, which is an inordinate length of time when compared to the claim value. 2, the service of processes and issues experienced with performing the functions provide a significant bottleneck in case flow. 3, over 50% of their pending caseload can, this is what the judiciary said, be immediately considered for clearance by mediation services. And 4, the lack of dedicated and consistent judicial and administrative resources contribute to backlogs and lengthy trial processes. Against that background, the judiciary considered, and we agree, that the global impact of small claims courts, that global impact is undeniable. The benefits of small claims procedures for contract enforcement, in particular, have been recognized by countries, corporations, and international organizations. The World Bank, in its Ease of Doing Business report, recently said that small claims courts and fast-track procedures are good practice for contract enforcement. According to them, and they surveyed 138 economies worldwide, they say that in those economies, they've implemented small claims courts or adopted a simplified, specialized procedure for treating with small claims, and that has had a positive effect on the ease of doing business. Mr. President, I should like to point out that there has been, as far as this part of the legislation is concerned, extensive stakeholder engagement exercises. The groups engaged by the judiciary, and this, I'm told that this exercise was conducted during the COVID-19 pandemic, included the legal fraternity, academia, mediators, banking and insurance, commercial lenders, debt collectors, large business entities, state agencies, service industries, the magistracy, and the public. The data gathered by the judiciary during that exercise, together with their research findings and court statistics, resulted in the proposed solutions which inform the legislation. There are in the legislation a few things which I'd like to highlight. Alternative forms of service of process, technological solutions including virtual courts, e-filing, e-payments, online dispute resolution platforms, ADR techniques, mediation, simplification of court procedures, processes, court forms to better accommodate self-represented litigants, and a system of appropriate public information and assistance tools and solutions to support court customers and self-represented litigants in particular. The small claims court service centers are proposed to be established physically within existing court buildings in Port of Spain, Arima, Couva, Siperi, and Scarborough. The locations will be determined by the judiciary based on an assessment of the volume of matters filed by location. I should like to turn now to the second bit of the puzzle, estates administration. Now, this is contained in Part 4 of the bill. Clause, is it Part 4? I'm sorry. It's contained at sections 29 to 32. The small claims jurisdiction is set out in Part 4 between clauses 13 to 28. So, in respect of the Estates Administration Office, which is contemplated by the legislation, the judiciary undertook extensive research on the activities of the probate unit as it now exists and generated a policy document in 2021 proposing the establishment of an estate administration office to replace the probate unit. The main proposals included a proposal to staff the estate administration office with specialized staff to support its operations. A lot of the delays were caused, according to their research, by persons who were not properly trained, given improper advice. There was also a suggestion to amend the Wills and Probate Act, that is Chapter 903. There were suggestions with respect to procedural and technological changes geared at enhancing the efficiency and overall performance of the Estate Administration Office. Now, we're all aware that the Chief Justice has belabored the point in several of his, the former Chief Justice, several of his opening of term addresses on the difficulties faced by those seeking probate. On the 16th of September 2025, at page 5 of his remarks, he noted that the Estate Administration Office, formerly known as the Probate Registry, has undertaken in the last quarter of 2024 a number of initiatives. They've dispatched 5,370 grants more than double the amount 2012 issued in 2023, which he said reflected a 105.6% increase in clearance rates. During the same period, the EAO, Estate Administration Office, he said, had completed over 13,000 searches, processed 11,000 filings, supporting thousands of applicants more effectively. And he noted that the gains continued in the year under review. That was up to 2025, when 3,151 grants were signed for the first 7 months, he said, of 2025. The legislative reforms seek to give a body to the efforts of the judiciary, which have already started to yield results. There is a probate registry e-services platform which allows applicants to track filings and to receive real-time updates, improving communication and reducing uncertainty throughout the process. Mr. President, the Estates Administration Office, established administratively, is already making significant impact on the administration of estates. And that has had a positive effect on the public and on business generally. The relevant clauses are to be found at clauses 29 to 32 of the bill, and they essentially now require that the business of managing the estate's function shall be performed by persons with the requisite skill, and including attorneys who are properly recruited for the purpose. Mr. President, I too, as my colleague, the Minister of Legal Affairs, I expect that this bill will have a smooth passage today. It is a bill that comes to us from the judiciary. Its provisions are non-controversial. There is no need for us to jump up and beat our chest and say, well, we did this, we did that. The fact is, you introduced the bill into the lower house, it was passed with amendments, but you failed to pass it in the Senate. Those are the facts. It died with other things that died in April of 2025. I commend the bill to the House, and I ask the unanimous support. Well, I should not speak for the independents, but I ask for the support of Senator Al-Rawi, who spoke. I checked the answer. I always do. I expect the support of Senator Al-Rawi and the members opposite in this measure. Thank you, Mr. President.
Honorable Senators, did you beg to move, sir? No, I think you should.
I beg to move.
Thank you. Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled an act to make jurisdiction for matters of a civil nature exercisable in a division of the judiciary to be known as a civil division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division, known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Courts, to make jurisdiction for estates administration business exercisable in a subdivision of the Civil Division known as the Estates Administration Office, and for related matters be now read a second time. Senator Faris Al-Rawi, SC.
Thank you. Thank you so much, Mr. President. I thank the Honorable Attorney General for the piloting of this legislation. We on this side will be fully supporting the law as it has been tabled before us. The bill before us is a bill to provide for the jurisdiction and creation of the Civil Division of the Court. It is an exact replica, clause for clause, word for word, of the bill which we laid in the House of Representatives and which we debated on the 20th of September 2024. It's word for word. Nothing wrong with that. The Honorable Attorney General has told us that he had... Yes, please.
Can I just point out that your bill had made it impossible to go to the Privy Council in respect of petty civil, what we now describe to be petty civil court matters. I took out that. It is not, in fact, an exact replica of your bill. It is the judiciary's bill, and I did some work on it. We did some work on it.
I'm happy that my learned friend anticipated where I was going. It is exactly the same bill, word for word, save for one material aspect, which is the removal of the passage to the Privy Council. There's one other position which has been maintained as we talk about right of appeal with respect to election petitions, as we preserve them pursuant to the Representation of the People's Act, and we all know that that ends at the Court of Appeal. So my learned friend, the Honourable Attorney General, is 100% correct. The Honourable Attorney General said that he had the privilege of, well, he had the caution of checking the Hansard, and I'm very happy that he did, because there are a few matters that I propose to address in my contribution that I would ask the Honourable Attorney General to confirm his views in respect of them, because they were raised in the context of observations of the law, and therefore I think it important to have a response in respect of them. So, Mr. President, the division of the court being created today is in fact with precedent. We as a government in 2015 to 2025 had the privilege of creating the Family and Children Division, which is certainly a law introduced on the 19th of February 2016 and brought into effect on the 10th of June 2016. We also had the privilege of bringing the Criminal Division and District Criminal and Traffic Courts Bill 2018, which then became Act number 12 of 2018. I must note that every time I hear the Honourable Attorney General speak, I'm usually very impressed by his smooth manner. He has a skill that few people have in keeping a calm head, a still tongue, and he manages to glide us past a number of things that are on the record. But in the precedent that we have, I'm very much interested in noting that the Criminal Division and District Criminal and Traffic Courts Bill, which had the very same structure of creating divisions, of using the Executive Court Administrator as we do in this law when we create the Executive Court Administrator's structures in the Civil Division, passing to the Deputy Court Executive Administrator, etc. What's curious to note is that the opposition, now the government, vehemently opposed that law. and said, as a matter of fact, in the vote when it was taken, that they would not support the divisions of court utilizing the executive court administrator, utilizing specialist staff, utilizing contract for 5-year periods, etc., which feature in this law. And when we go to the positions that we're addressing today,
Can I?
part one, yes, please.
So I have to apologize for the fact that I did speak to the law which is before us. I propose to move certain amendments at committee stage. I don't want to steal your thunder. You're doing very well. But one of the things that I am going to treat with is that issue of the deputy court administrator. So don't get yourself hung on that tree.
Thank you, Honorable Attorney General. Again, perhaps, anticipatory of the point that I was going down, because there are matters on the record in relation to the structure that I know the now government has deep concerns over, because the first objection to the treatment of the executive court administrator and the deputy court administrator featured in the criminal division laws, which we sought to bring into effect in 2018, and which in fact the then opposition, now government, strenuously objected to. But in relation to this law, if we go to the three purposes, the three elements that we're creating today, we're creating a civil division, we're mirroring and completing the process of bringing to life a judiciary. We have the judiciary, it exists under our Constitution. There's an entire chapter on the judiciary. We have the Supreme Court of Judicature Act. We have the magistrates, which are creatures of statute. We have masters who are creatures of statute. There are a number of laws that tell us how the judiciary ought to operate. But, Mr. President, the creation of divisions of court with a heavy centricity on administrative structure is a critical feature of this law, as we see throughout the bill. If you look to the small claims, if you look to the civil division, if you look to the estate administration, they are all underwritten by very specific language which says how the administrative arm of the judiciary is to be managed, what qualifications one has to have to occupy positions, what the hierarchical reporting system will look like. It maintains the Chief Justice as the person who has the authority to manage the judiciary, and it creates the use of tools, filings, and other structures. Now, you may ask, why do this? Again, one, for the process of continuity and completing the creation of divisions, but really and truly because when we look to the administration of justice, there has always been a complaint in relation to the administration of justice. My mind went back to something that I found, which is a report on the system of administration of justice in the colony, 1896, by a committee appointed by then governor of the colony. And the recommendation coming out of that took careful notice of staffing issues. Now, when we deal with staffing issues in this bill, we deal with it at clause 12, we deal with it at clause 23, we deal with it at clause 32, we deal with it at clause 36. Clause 12, we're underwriting the staff and population for the civil division. Clause 23, we're dealing with the staffing of public officers and contract workers for the small claims court. Clause 32, we're dealing with the staff of the estate administration office. Clause 36, we're dealing with the administration of the civil law department. It's a critical feature for the anchoring of staff in the manner that we bring. But back in 1896 and then again in 1956, it was noted, and I wish to quote here, "But we desire to call your excellency's attention to the fact that for the most part, appointments to clerkships in the registrar's office have in the past been made without any regard to the previous training of the gentleman appointed. The registrar's office, and they're referring to the registrar of the court, appears to have been regarded as a government department to which a clerk could be promoted from any other office and promoted again from it to another. In point of fact, the registrar's office is one that requires special training before a clerk can properly perform his duties, and no one, however great his general ability and official experience may be, can properly do this work without some preparation. That was back in 1896. That was back in 1956. We fast forward to the late 90s and we look to the Green Slate reports when we're looking at access to justice. We come forward to 2005. But the real reform of the judiciary occurred in the period 2015 to 2025 with fundamental changes to the structure of the judiciary, as it appears in this bill. It was specifically the intention that, as opposed to dealing with the general law and filling in the blanks, we had to capture, as this bill captures, the real mischief. And the real mischief was born in 1977. In fact, it was born on the 24th of May, 1977, when the Judicial and Legal Services Commission was created and carved out of the civil service. The problem that still exists today, and I asked the Honorable Attorney General to take note of it and to take action on it. It's something that we had an active work product on, featuring in this bill. The position is that there have been no classifications or reclassifications by way of order for the staff of the judiciary falling under the Judicial and Legal Services Commission. And that has left a serious problem for us to wrestle with, and that is part of the background which underwrites the law that we're bringing here today. So the mischief that we're treating with, by treating with staff specificity, by providing for suitably qualified persons in the clauses that I've just mentioned, Clause 12, Clause 23, Clause 32, Clause 36, in providing for the suitably qualified persons to be employed either from the public offices, public service, or by way of contract, under the supervision of the Court Executive Administrator and the Deputy Court Executive Administration. That is what allows the law to now go to work. And therefore, we commend that purpose. In fact, it is important to note that whilst the Honourable Attorney General correctly says that the judiciary does not sit at the table in Westminster, but has to be acknowledged as having driven work products, I'd like to also put on record that it is the Cabinet of the Republic of Trinidad and Tobago in June 2019, when it considered specialized staffing of the Estates Administration Office of Trinidad and Tobago, on June 8th, 2020, when it considered staffing to facilitate the management of the Civil Division of the Judiciary of Trinidad and Tobago, the Cabinet again on April 15th, 2021, when it sought the establishment of Small Claims Court in Trinidad and Tobago, and the Cabinet again on November 8th, 2021, when it sought to anchor the establishment of the Civil Division and Judiciary of Trinidad and Tobago. It was the PNM Cabinet that went to work to bring to life the administrative structures upon which this law now works. Now, one may ask the question, why didn't you bring the law first? And the reason that the final civil division was not brought forward is simply because the manpower and resource identification inside of the judiciary, ultimately, if you looked at it fresh, requires a massive number of persons. However, there were offices in existence at work at the judiciary that could easily have been closed off and persons reassigned so that the state wouldn't be paying more money than it should by simply hiring persons. The cabinets and the cabinet decisions that I've just referred to, in fact, authorized the management of the human resources in the judiciary and authorized the implementation of reform by way of human resource reform and intellectual technology and other property and tool reform bases to allow us to go to work. A very big part of the reform undertaken and which this law proposes is the use of technology. It allows for virtual sittings, it allows for e-filings, it allows for payments into and out of court, all by electronic means. And I should ask you to note, Mr. President, all of those were resisted by the UNC in opposition, every last one. Today, they feature in the bill, and commendably, the government has now accepted the propriety of these measures. The government has accepted the propriety of the divisions of court model. It's not lost upon me that the now Minister of Defense went to court to sue the government for the criminal proceedings rules coming out of the criminal division, and that therefore today we're seeing a wonderful change of character. We're seeing a UNC party as government give a complete change of position in relation to the law. For 10 full years, there was opposition to this kind of reform. But let's turn to the terms of this bill. When we get to the bill, there are a few critical points that I think are important to observe. And let's start with the Estates Division, the Estate Administrative Office. And that Estate Administrative Office is a very important tool because it affects in Part 5 of the bill, clauses 29 to 32, we're creating this Estates Administration Office. Very importantly, it includes, in Clause 32, estate administration attorneys and an appropriate number of persons referred to in 2. Now, when we go to what estates administration looks like, it's very important to note that everybody has to embrace this estate administration at some point or the other. There, in fact, are a number of laws, 17 of them, which treat with the administration of estates. The Wills and Probate Act, the Administration of Estates Act, the Civil Proceedings Rules 1998, the Distribution of Estates Act number 28 of 2000, the Succession Act chapter 902, the Adoption of Children Act, the Age of Majority Act, the Distribution of Estates Act, the Family Law Guardianship of Minors Domicile and Maintenance Act, the Finance Miscellaneous Provisions Act 39 of 2000, the Interpretation Act, the Mental Health Act, the Public Trustee Act, the Registration of Deeds Act, the Stamp Duty Act, the Status of Children Act, the Supreme Court of Judicature Act. 17 laws fall into consideration when you're dealing with someone's estate when they pass, either because they've left a will, or they have not left a will and there's administration of the estate required, or there's bona vacantia, meaning it goes to the state because nobody's entitled to it. But our probate registry for many years has only ever seen, at best in terms of filings every year, a 1/3 completion. So 2/3 goes into arrears every single year. And in the period 2019 to 2025, the government of which I was a part, and as Attorney General for a large part of that period, I too find pride in the reforms that we were able as a government to advance in the creation of divisions. But we went to work by introducing critical amendments which work with this law. The e-lodgement policy, so that errors and corrections can be found. The removal away from a hybrid position, where you were using an archaic GEMS model, which is the judiciary IT, together with paper filings, into the TT GIMS system right now. So we have had a significant advance, but 99% of the problem, solved by Clause 32 now, is that we had clerks who have absolutely no legal experience supervising the works of attorneys at law, and therefore conflicts in trying to understand the law as it's being presented to them. This law changes that by the use of effectively administration attorneys. That means that you remove the odium of the Registrar General who acts in probate and administration matters in approving and making the recommendations of having to advise himself. And therefore now you have the estate attorneys, the administration attorneys, presenting this work, but with the use of suitably qualified persons either from the public service or from the private sector on 5-year contracts. What we're having now, again repeating the criminal division, again repeating the civil division, the family and children division, what you're having now is the right fit. No longer square pegs into round holes. You're getting an actual anchoring of a solution. If we go to the position on the Small Claims Court, the Small Claims Court under the Petty Civil Act is effectively asking magistrates who occupy the vast amount of their time in criminal matters and summary matters, in their time management, to now deal with small claims. The nomenclature was a problem. Petty civil. The fact that you're limited under $50,000 was really a serious problem because the Petty Civil Court does not have, under the Petty Civil Act, equitable jurisdiction. It cannot fashion a remedy beyond the confines of the law. But the real problem with the Petty Civil Court and the Petty Civil arena is that the law and the procedure were in legislation. What we do here in this bill, by way of critical reform, is we repeal the Petty Civil Act. And instead, you widen the jurisdiction of the court. You allow for equitable considerations in Clause 14. You give the court equitable relief. But very critically, you put the rules of the Supreme Court under Section 77 of the Supreme Court of Judicature Act to go to work to fashion what the petty court will look like. And very importantly, we establish what the pecuniary jurisdiction is going to be. Now, what is the pecuniary jurisdiction? In this bill, the pecuniary jurisdiction is where you set the limit. Currently, the petty civil arena is run by claims as amended, $50,000 and under $50,000. But from time to time, if you take the RPI index, if you take inflation, etc., it may be wise to raise those. You can't come to Parliament every day to change the limits. It can be done under the Supreme Court of Judicature Act. Practice directions, rules of court, etc. can all come. So this law provides a critical aspect of reform that really takes us a massive leap ahead, none of which could really have happened until we got the technology right, which we laid out in the Family and Children Division and in the Criminal Division. But, Mr. President, may I remind you, prior to occupation as Attorney General, when we inherited the court system, the magistracy was run on paper with no digitization. Records and transcripts had to be manually written out. You had to stand up and call a name. Clerks of the peace were not attorneys at law who were functioning as lawyers effectively in contravention to the Legal Profession Act. All of that was changed. All of that reform went into place. So why wasn't the Civil Division bill brought before? Because we had to, as I used to say then, we had to fly the plane while we were building it. We had to engage in the reforms, put in the virtual settings, put in the centers of consideration, put in the backbone and IT and support, have electronic filings, have electronic payments, have virtual attendances, remove clerks of the peace who offended the law, remove police prosecutors who were not attorneys at law. So there was an incredible exercise in improving the administration of justice in the last 10 years, and one of which I am extremely proud to say our government managed very successfully, notwithstanding the considerations coming from the then UNC opposition. So, Mr. President, that's the Small Claims Court. That is the estate administration. The civil division itself borrows an actual structure almost word for word as the Family and Children Division and the Criminal Division. But, Mr. President, in looking at the Hansard, I recall, because I contributed to the debate back in 2024, on the 20th of September 2024. But I paid very close attention to the observations of the Leader of the Opposition, now Prime Minister, Learned Senior Counsel, Mrs. Kamla Prasad-Bisesa, the member for Siparia. And there were some very stark observations that I hope the Honourable Attorney General will help us with today. Perhaps the amendments that he's indicated are to come may deal with these. But when we look to the statements of the member for Siparia, the first thing that struck me, if I may, from her Hansard reflect, the Honourable Leader of the Opposition, now Prime Minister, said, these are some of the bill's essentials, but there are some other contentious areas when it comes to staffing and the use of contract employment. The Honourable Leader of the Opposition, now Prime Minister, said it will require financial autonomy for the judiciary. The Leader of the Opposition asked in relation to this bill, and I wonder if the Attorney General will provide us with answers, what of the financial autonomy that the Leader of the Opposition, now Prime Minister, said should happen and agreed with, but had not. She correctly chastised the then government that in 2016, 17, 18, 19, 20, 21, 22, 23 to today, that there hadn't been significant financial autonomy. So I wonder if the Honourable Attorney General will be speaking to that. Is it the government's intention to grant financial autonomy? I put that on by way of question. Here's what Mrs. Prasad-Bisesa had to say. We must be wary of hasty, ill-conceived provisions as stopgap measures to assuage the understandably fed-up population, to give the impression that we care. It is clear, in another part, that certain of the provisions here in this bill could run afoul of the law of Trinidad and Tobago and encourage corruption in hiring practice. Government will take heed and take necessary remedial action, she called. In relation to Clause 18 of this bill, which was Clause 18 of that bill, the Honourable Leader of the Opposition, now Prime Minister, says, firstly, I will say on this issue of hiring, Clause 18 of the legislation, the bill seems unclear as to the standing of magistrates against the masters and puisne judges. The clause does not envisage how this may be reconciled, and that was the Honourable Leader of the Opposition reflecting upon inherent jurisdiction of judges versus the jurisdiction being tied to statute for magistrates and masters. I have not seen a change in the language today. So I would like to know from the Honourable Attorney General, was the Leader of the Opposition correct? Are the serious concerns of now Prime Minister being addressed by maintaining exactly the same legislation that the PNM government brought into effect and which had serious complaint from the Leader of the Opposition, now Prime Minister? How are we to accept that a serious issue has disappeared just by a change of name, opposition to government? Clause 23 of this bill, which was Clause 23 of that 2024 bill, the Leader of the Opposition had this to say. Clause 23 allows the court executive administrator to recruit persons on contract. Questions about recruitment processes for these positions. What is the process? What are the names, titles of positions? Would these be approved by the Personnel Department? This legislation does not limit the person exercising this power, and I'm reading excerpts. The use of the word persons is highly inappropriate. That's at page 52. When we get further down, how many are we talking about that we're giving the court administrator this power to hire and fire persons on contract? It is not the function of cabinet to approve. Is it not the function of cabinet to approve posts? Later on, this means it does not affect the judiciary's independence, and therefore the legislation in some senses seeks to usurp the role of cabinet. I ask the question today, what of these concerns? The law that has returned today is exactly the same as to these provisions. Where have the concerns of the Leader of the Opposition, who is now Prime Minister, settled? Is it that we were correct in 2024, that there's nothing odious in this law? If so, I think it only fair that an explanation is offered, let alone an apology is given. Clause 34 of this bill. In respect of Clause 34 of this bill, and this is the bit that I'd be intrigued to hear what the Learned Attorney General has to say, was reflecting on the position of the Deputy Court Executive Administrator, Contract and Public Officer. The leader of the opposition, now Prime Minister, had this to say: so is this deputy CEA a civil service post or contract post, given all this power, placing the power in the hands of the deputy and, of course, administrative officer? Perhaps that's the amendment that the Honourable Attorney General is bringing. I look forward to seeing that at committee stage, if so that we can analyse this. But if the Deputy Court Administrator still stays, regardless of whether it is a public officer post or a contract officer post, the Leader of the Opposition, who is now the Prime Minister, asked on what basis does the DCA equate to a Deputy Permanent Secretary, a DPS, because the Honourable Member could not factor that the law could state that you can just assign a post. Now, I hold a very different view. The role of the SRC under Section 141 of the Constitution is to consider terms and conditions, but it is the role of the legislator, the legislative arm of government, to define categories. For example, you may create a new law, you may establish posts and set them up. It is the law that creates the entity and the post, and this law certainly can. That's my view. Apparently, the Leader of the Opposition, who's now the Prime Minister, does not share that point of view, because on her Hansard in September 2024, the Honourable Leader of the Opposition, who's now the Prime Minister, did not agree, as I understood it. Here we have at page 55, again we remind the government there is a policy that job titles for permanent positions and contract positions cannot be the same. And we look at that conflict, madam. There is a conflict when we come to contract employment, because you see there are guidelines to be approved. And the Honourable Leader of the Opposition questions what is today Section 32B, the same section, saying that there is a conflict with Cabinet approved, and that the CPO guidelines, which are still in effect today, cannot allow Clause 32(2)B to exist, as I understood her contribution to be suggesting. I therefore ask, what has changed in a matter of months? How is it that there could be such vehement opposition to the principle behind the law then, and today it is okay? Mr. President, the Leader of the Opposition had a serious problem with 5-year contracts and said that there was no place for 5-year contracts, that it could only be a 3-year contract. Today, the Cabinet, which the Honourable Member for Faris supervises, brought a law which provides for 5-year contracts. What has changed? These are serious issues when we ask for non-contentious debates and we say that we've made good points. What has changed insofar as September had 5 years and today we have 5 years again? Mr. President, this was no small submission by the Leader of the Opposition, who is now the Prime Minister. Why put a provision at 5-year contracts in the legislation? The Honourable Member asked. That reduces flexibility in negotiating, and there is a creation of legitimate expectation. Why are you advocating for these long-term contracts? This is a breach of industrial relations practices. Well, why is it not a breach of industrial relations practices today with exactly the same formula for 5 years? We must ask, and we must have an answer. Mr. President, the Honourable Leader of the Opposition, in relation to this law before us today, then said there's a common thread, a golden thread running through all the arguments, is the proliferation of contract employment in the public service. The whole thing is to be staffed by contract employees. You don't have security of tenure. You can't get a mortgage, can't buy a car. You know what? You don't know what day you're going to be fired, when your contract will expire. Well, we understand that now because many people who are on contract understand how easily they can be dispensed with under this government. But, Mr. President, the Honourable Leader of the Opposition, who's now the Prime Minister, said this proliferation of contract employment is one that needs to be seriously reconsidered. So, Mr. President, in these 42 clauses before us, how come there has been no reconsideration of 5-year contracts, of the use of contract employment in the manner that the now Prime Minister had serious problems with? What has changed is my question. Mr. President, the Leader of the Opposition, now Prime Minister, went further. in relation to these contract terms, here's what the honourable member had to say. Really places an individual in a very inhumane position. Extremely difficult economic climate created by these policies. Anti-people policies. You know what I always say, P&M, people never matter. What happened? How has that changed? Do we have an acronym in relation to the UNC that we could trade today? I would respectfully ask the members contributing opposite to answer these questions. What has so radically changed between September 2024 to allow you to bring exactly the same terms and conditions, save for two aspects of the law which we'll hear from in committee stage? Mr. President, the Leader of the Opposition, in relation to Clause 33, which is the same Clause 33 that we have today, thank you, Mr. President, said that why have a central coordinate office? This is a waste of money, she had to say. Today, Clause 33 repeats the same central office, the same coordination. We hold the view, as we did in September 2024 and prior, that you absolutely have to have a central coordinating office so that there can be a streamlining, because the divisions that operate in respect of the summary courts and now the small claims courts are divided between North Trinidad, South Trinidad and Tobago, just like the summary arena is done on the criminal side, but that you have an assignment and reassignment with fluidity, and in a virtual system, as this law offers. We believe you need that, but the Leader of the Opposition, now the Prime Minister, called that a waste of money. So if the Honourable Attorney General or members opposite could explain how Clause 33 is no longer a waste of money, we'd be very grateful. Never before have we seen independent institutions kowtowing to the will of the political directorate. Wow. That was a statement by the Honourable Leader of the Opposition, the now Prime Minister. Let me repeat it. Never before have we seen independent institutions kowtowing to the will of the political directorate, as we have seen over the last 9 years. Is this another attempt to continue with this policy, jeopardizing our democratic institutions? I mean, I think perhaps the Honourable Member was correct, because never before have we seen it in 10 months, equal to more than 20 years in the fashion that it has been ruled out by this government. Mr. President, in relation to Clause 36B, which is word for word the same today, the Leader of the Opposition said this legislation is loose and requires clarity. Well, what changed? What made it tight all of a sudden? What gave it clarity in respect of these matters? Administrators set the terms. Listen to this. In relation to that the administrator is to set terms, and a question on that. This is the Leader of the Opposition statement. That will be ultra vires several pieces of legislation where the CPO acts on behalf of the employer in negotiations. It cannot be the court administrator. But today, it is the court administrator. Is it that the government doesn't take their learned senior counsel, the Prime Minister, seriously? Is there an explanation to be given? How can you go from so vehemently sure that the law is ultra vires to then sit in the cabinet and approve exactly the same formula if it wasn't that you were just simply wrong and opposing for opposing's sake? The Honourable Leader of the Opposition at 3:10 p.m. on that day said, are we setting up a fiefdom here? Wow. I have to ask the question, if this law is the same law that has returned, say for the amendments, the AG will bring in two aspects in a short while, one for the Deputy Court Administrator. What has happened to the fiefdom? All of a sudden it is not a fiefdom? Mr. President, the Leader of the Opposition said that anyone who has served in a cabinet would know about the notes. You had to hire persons, job titles. The Leader of the Opposition went on to say, so this is what the cabinet gives us about guidelines. The Attorney General tell us, superseding. The Honourable Leader of the Opposition had serious problems about Clause 31. She went on to say it is important that we do not give false hope to hundreds who are still languishing and look to resolve key issues. Mr. President, I've put these things on the record because They came from no less a person than the head of the cabinet now, and they reflected upon considerations given after careful research in September 2024, as the member for Siparia said she had engaged in careful research. But today, the question has got to be, what has changed so dramatically? I've laid this on the record of my contribution to simply point out that at no point in time will you see this opposition vacillating simply because we're not in power. We have stood in defense of the law as a loyal opposition must. We respect the democracy of this Parliament, of this Senate, of the House of Representatives. In certain circumstances, a simple majority prevails, as it can. It's just simply important to bring it to your attention. Thank you very much, Mr. President.
Senator Michael S.V. Bastide, SC.
Thank you, Mr. President. Mr. President, let me first apologize for arriving late this morning. And let me just say at the beginning of my contribution that I'm sure, as everyone else in this chamber, I support wholeheartedly the purpose of the bill. And I support, by and large, well, I support the means by which it seeks to achieve that purpose. But in reading the bill, I had a question arise in my mind, which, given the fact that we have been told that the bill has really been, in large part at least, drafted by the judiciary and presented to the government, that they would be able to answer the question. And no doubt they would have done a considerable amount of research, which I have not been able to do, given the time constraints that the chamber is under. In putting, the question really is, if I could just summarize it at the beginning, is whether the bill is creating a new high court in addition to the existing high court. And so is it that we will have two high courts? And if so, how does that gel with the constitutional arrangements that are in place? And in communicating how that question arose in my mind, let me just go through quickly some of the clauses of the bill. And I start with Clause 4. And Clause 4 provides for a civil division of the judiciary, which it says shall comprise of, amongst other things, a civil court. Now, judiciary is not defined, so the courts will interpret that in its ordinary meaning. But civil court is defined in Section 3. It's defined as a high court established under Section 5, exercising jurisdiction in civil matters. So if it's a high court that is established under Section 5, then it seems to suggest that it is a high court in addition to the existing high court, which is constituted under Section 4.1 of the Supreme Court of Judicature Act. Clause 5 provides that upon the commencement of this act, I quote, authority and jurisdiction in civil matters exercisable by the High Court shall be exercisable by the civil court. So at least one interpretation of that is that the authority and jurisdiction in civil matters exercisable by the High Court that was established in 1962 under the Supreme Court of Judicature Act will now be exercisable by the civil court, which is constituted under Section 5. And I notice as well, in support of that possible interpretation which I'm putting forward, this bill is different from the Criminal Division Act, and it's different to the Family Act, which created the family court and so, in that those pieces of legislation in constituting, if you like, specialized courts, family courts, criminal courts, children courts, those courts were not really courts in themselves, but they were divisions, because the legislation provides that for divisions of the High Court, which are to be called criminal court, family court, and so forth. So those courts, when we say they are a family court or a criminal court, those are really divisions of the High Court. So the High Court, we still have one High Court in place. But this bill seems to take a different approach. It does not provide that the civil court is a division of the High Court. It defines civil court as a court, a High Court established under Section 5. So this goes towards my interpretation or construction of the Act as possibly creating another High Court, and we have two High Courts. And then, well, a side issue, if you like, is that when Section 5 or Clause 5 says that the authority and jurisdiction in civil matters exercisable by the High Court shall be exercisable by the civil court, I'm not sure whether that means this is authority and jurisdiction which can only be exercised by this new civil court, or whether it can be it's still retained by the High Court but can be exercised as well by the civil court. So that's a bit unclear to me. But the central question that I have in my mind is this act purporting to create this bill to create two High Courts? And if, Mr. President, we go to let me just look quickly at I have it now, the Family and Children Division Act 2016 and the Criminal Division Act, Criminal Division and District Criminal and Traffic Courts Act 2018. And if I start with what I call the Family Act, as I say, that act makes clear that the family court and the children court are really divisions of the existing High Court, so that the act does not create a new court, only divisions of an existing court, that is the High Court. Similarly, we have what is referred to as a criminal court that was constituted by the Criminal Division and District Criminal and Traffic Court Act 2018. But as Section 4 of that act makes clear, the criminal court refers to is just a label. Criminal court is just a label that refers to a criminal division of the existing High Court. It does not establish a new court or a new High Court. So neither the Criminal Division and District Criminal and Traffic Court Act 2018 nor the Family and Children Division Act create new courts. They merely create divisions of the existing High Court. Now, I appreciate that the civil court in this bill forms part of a division called the Civil Division. But that division is not a division of the High Court or of any other court. It is a division of something called the judiciary, which, as I have said, is not defined. So, in summary, whereas the Family Act, I'll call it Family Act for shorthand, and the Criminal Division Act, which I call that for shorthand as well, whereas those pieces of legislation create divisions in a court, this bill creates courts within a division of the judiciary. So, the question is, does is it the legislative intention to create 2 high courts? If not, and I suspect not, I expected that isn't the intention, I could be wrong, then perhaps the legislation should be amended or the bill should be amended so that it provides that the civil court is merely a division of the High Court in the same way that the Family Act and the Criminal Division Act defined those specialized courts were really divisions of the High Court. They were not courts in themselves. They were just divisions of a broader High Court. Perhaps we should do that. If the intention is that we have an additional High Court, separate and apart from the existing court that we've had since 1962 under the Supreme Court of Judicature Act, then it is necessary to consider whether that gels with present constitutional arrangements. In that regard, I just refer quickly to Section 99 of the Constitution, which provides that there shall be a Supreme Court of Judicature Act for Trinidad and Tobago consisting of a High Court of Justice, hereinafter referred to as the High Court, and a Court of Appeal with such jurisdiction and powers as are conferred on those courts respectively by this Constitution or any other law. That section, Section 99 of the Constitution, and Section 100 of the Constitution, in my mind, clearly contemplate and provide for a single High Court. And it seems to me, and at the time of the Constitution, that High Court was constituted by the Supreme Court of Judicature Act, which I believe was also passed in 1962, probably around the same time. And it seems to me that is why, because the Constitution contemplated for a single High Court, that is why when we passed the Family Act and the Criminal Division Act, I'll call it for shorthand, that is why we created these specialized courts as really divisions of a High Court, because it recognized that we have one High Court under the Constitution. And we can create specialized courts, if you like, to deal with specialized areas of the law by creating divisions within that court. So the creation of a new, if that is the intention, if it is the intention to create a new High Court, a second court, then it seems to conflict with the Constitution, and it would seem to purport to amend the Constitution. And if that's really the intention, then I think the appropriate clause required under the Constitution, which says that it is this act or this bill is to be construed as amending the Constitution, should be inserted. I think the relevant provision of the Constitution requiring that kind of clause is under Section 54(5). And then if there are to be 2 High Courts, then the government or the judiciary may want to consider, well, what is the consequence of that on the other existing legislation which refers to the High Court? Because does it need to be amended to indicate which High Court it's referring to, or if it's referring to both High Courts? Now, the answer to the question may be, well, you know, the judiciary will leave it to the judiciary to construe whether it's a new High Court, and maybe the answer will be clearly that's not what's intended, and they will construe it accordingly. But why leave it to chance? Why leave that uncertainty? This is not criticism. This is simply a question that perhaps there's an answer for. Why did we not, or why did the judiciary not keep Central High Court? And if you want to have a civil specialized court, simply define that court and as a division of the High Court. There shall be a civil court. Well, there shall be a division of the High Court known as the Civil Court. So, Mr. Speaker, but apart from that, I very much welcome this, Mr. President, sorry, forgive me. I very much welcome this legislation, the bill, and I'm sure the present Chief Justice and Judiciary and past Chief Justices will be very happy that it's being passed or is being presented. So thank you, Mr. President.
I want to suspend, I would like to suspend at this time and come back at 1 p.m. So we can have lunch. So this sitting is now suspended until 1 p.m. Allahar. The leader of government business, Senator Darrell.
Thank you, Mr. President. I'm happy to see that everybody is so bright-eyed and bushy-tailed here this morning, especially on the other side. I know you all have been out late last night. I hope the Fed didn't bust. Okay. Mr. President, we've been moving along at a clip. And I dare say we should hold more sit-ins on Kest Tuesday so we can get the work done very quickly. But we hit a little bump and we slowed down when my good friend Senator Al-Rawi, who is not here, spoke. And it gave us an opportunity to respond to some of the things he said. And there are two areas I want to respond to. First of all, one would have thought that Senator Al-Rawi was moving the bill when he spoke. But this is not 2024, Mr. President. Civil Division Bill 2024, Civil Division Bill 2026. It is a bill that was brought from the judiciary to this place because the judiciary couldn't bring it itself. And therefore, Mr. President, I want to probably inform Senator Al-Rawi that, in the words of Shakespeare, a rose by any other name is still a rose and smells just as sweet. I don't talk to the Archbishop, I talk to the one upstairs. I will get back to that before I complete the contribution, but I'm actually very excited. I'm not going to stay too long, but I'm very excited to rise today because this bill speaks about a lot of matters which are very close to my heart. Being a former assistant registrar of the Supreme Court 28 years ago. So I can't help but feel a bit nostalgic. In those days, 28 years ago, and the point I'm making has to do, before anybody jumps up, has to do with staffing and management of human resources. 28 years ago, as an assistant registrar, we were jacks of all trades, as it were. We perfected civil orders. We sat and presided over registrars' courts to assess bills of cost, tax bills of costs. We held workmen's compensation hearings. We certified uncontested divorces. We performed plant and machinery assessments. We were in charge of the whole of justice. We had to know every inch of the building and every floor, including secret floors. You all never knew that. And yes, and we had to do performance management, assessments of civil servants. We had to help with interviewing people for positions by delegated authority of the Service Commission. We had to manage the accounts because the registrar was the accounting office of the judiciary. And there were lots of things that we had to do assisted by clerks who were public servants who were put there by the Public Service Commission. And we even had to help execute condemned criminals. I remember saying goodbye to at least 10 of them between 2000 and 2001, an interesting experience, and I hope to speak about that one day, but not today. So when we speak about human resource management and we speak about staffing and we speak about giving the judiciary the tools and the ability to hire, it's because of a long-standing problem. Senator Al-Rawi asked the question several times. He seems to have a fixation with the Honorable Prime Minister. What has changed? What has changed? As the Honorable Attorney General said when he opened, it is the duty of a government to bring to the Parliament measures which can assist the judiciary. And they must be brought within a constitutional structure. So Senator Al-Rawi is not here, but through you I would want to tell him opposition is opposition, but government is government. And we have a duty to help and assist the judiciary to perform its mandate and perform its role. It should not be lost on any one of us, Mr. President, and it's probably the ghost in the room, I would say the ghost in the machine, that this bill and the measures in this bill as it relates to the hiring of staff on contract is because of the failure of the Service Commission system under the Constitution. I'll give you an example of it. In 1998, we started the Judicial Sector Reform Project. I worked with Justice Greenslade on the new rules of court. And we went through a period of training our clerks in the new rules of court, giving them lectures, administering exams, so that they may be identified for any rules that we hope that the Service Commission would classify them in, which never came to be. And a lot of the staff that we trained who had experience left the department because they were either seconded or they were promoted out of the department. There was no certainty. And coming back to this bill, what this bill does is within our constitutional structures, which successive governments have tried to work around because of the behemoth service commissions, is for Cabinet to create contract posts to fill departments. As the Honorable Prime Minister said last week, Thursday, on the occasion of commemorating the head of the public service in office, Miss Natasha Baru. She was confirmed. And in her speech, the Honorable Prime Minister lamented at the fact that we still have public officers who retire acting. Okay? We still have people who are public officers who are caught in a time warp because their disciplinary matters take years to complete. Positions have not been filled for years across ministries, and every government complains about it. And what we have done over the years since independence is we have all found a way to work around it, but it's not the best thing. And this bill is reflective of that, which is to give somebody the ability to hire on contract for 5 years. It's not the best system, but as a government, we have a duty to enable the judiciary to do it because the Service Commission is not doing it. It's as simple as that, and that's something we need to reflect upon, and I hope that it's something that comes back here for us to reflect upon further at some point in time, because we cannot continue like this. It is absolute collapse. And there are other reasons for that. I mean, you have to look at how persons are appointed to these commissions. I'm not going to say more of that, but everybody knows there's the ghost in the machine. And sometimes you have partisanship and politics masquerading under the cloak of independence. I wouldn't say more about that, Mr. President. But that is how it is. It's a deep state P&M thing going on sometimes. So while we all celebrate across the aisle about this bill has uncovered and reflects a deep constitutional difficulty that we have. And nobody seems to have found a way to grapple with it. So we have a duty to assist the judiciary, which is the other arm of the state. I want to move now to some happier matters before I complete it. I'm very happy to see that we are enabling a small claims court. Some of us would remember the Judge Judy series on the television. I don't think it will be like that, but certainly it is reflective of the ability for small disputes to be determined with a cost-effective basis. Because for the small man, a dispute of $10,000 because the mechanic did not fix his car, or the landlord doesn't want to pay him back his deposit, it's a lot of money for some people. I remember as a young attorney, my seniors would give us young attorneys the small claims, the petty civil court brief. And after the matter is adjourned for 5 times, you realize that you couldn't find it in your heart to charge the client anything more, and it became pro bono. And that was simply because of the administrative arrangements for petty civil courts in those days, which still exists in some shape or fashion now, but we're getting out of it, which is the magistrate would leave. First of all, you had traffic courts, you had charge courts, and they would deal with the busy, those are the busy courts, those are the criminal ones. But the magistrates who were in charge of domestic violence, those would be dealt with at the end of the list because of the sensitivity of those matters. And it's only after all of those things are done, the magistrate would get around to the small claims, the petty civil court claims. Because liberty of the subject, of course, is of paramount importance, and you dealt with those hearings first. But by the time it was 2 o'clock in the evening, everybody was tired, like how we're tired now. And the magistrates would not give you much time to deal with the matters. And the list got bigger and bigger and bigger to the point where you would have to wait in court just to have your case adjourned. And every time the case was called, you had to pay your lawyer something. And from some of the last judicial reports, we see an average of 5 years for some of these matters under $50,000 to be determined, if at all. Unfortunately, the judiciary hasn't given us any updated reports past 2020, I believe. That's the last one I saw on the website. So we're hoping that in its next report, we can get 2020, 2025 at least. But in 2020, there were more than, well, a little under 5,000 petty civil court matters in the system. which was still active. They were talking about an 85% disposal rate, but those metrics did not tell you whether matters were disposed of because they were dismissed for non-attendance. People just got fed up and didn't attend. Or they were dismissed because they were mediated. Okay. So I'm very, very happy that we are formalizing this small claims court jurisdiction. And I'm happy that we are giving the judiciary the facility to do two things. It is framework legislation. We are giving the judiciary the facility, first of all, to set the petty civil court limit, which is set at 50,000 now. But they will be able to set it based on what they think is reasonable in the circumstances. And also giving the judiciary the ability to make its own rules as to how matters progress. Just as how we have standing orders here which regulate what we do, courts have rules to regulate what they do and to regulate their jurisdiction. Certainly the CPR, as we have for the High Court now, is not a good fit for small claims, because by the time you go to 3 case management hearings, that might be the size of the claim itself after you pay your lawyer. So it's not a one-size-fits-all. So I'm very happy that the courts now, through the Rules Committee, will be able to make rules appropriate for fast disposition of these matters. And those of you who are not in touch with the ground would not appreciate that we have a lot of disputes out there that people just don't bring anymore because the inefficiencies of the petty civil court system, which has been going on since 1911, as a speaker said. It's like the Oliver Twist of the court system, the ignored orphan. So I'm happy now that we have a champion in getting it done, and I am very confident that the courts will now roll this out and we will see a difference, because those are the disputes that affect the everyday man. The last point I want to make is to at least attempt to answer Senator de la Bastide. I understand the query in relation to, I think the issue was whether the High Court exists or whether this is a parallel High Court. It really is a question of nomenclature and what we've been advised by the draftsmen. The Constitution sets up the Supreme Court consisting of the High Court and the Court of Appeal. The Supreme Court of Judicature Act clothes the judges of the High Court with jurisdiction. That had existed since independence and even after. So the Supreme Court of Judicature Act is a jurisdictional statute. It doesn't create the judges. But what we do here, unlike the criminal division, family division, is that there is a civil court, small claims court, and estates administration office, which is part of a civil division of the judiciary, not the High Court. It can't be a civil division of the High Court because we have magistrates sitting in the small claims courts. And that's the distinction. Magistrates are not members of the High Court, they're not judges. So it really is an administrative label. So we have a civil division of the judiciary, which has a civil court, small claims court, which includes the magistrates, and the estates administration office, which includes attorneys who can deal with non-contentious probate matters. So we could never call it a civil division of the High Court. I hope that answers with respect to, so it really is a for drafting convenience. So it's a division, and it's historical simply because under the original way the courts were structured after independence, every judge of the High Court had the plenary of civil jurisdiction and criminal jurisdiction, both under common law and under the Judicature Act, so that you can put any judge in a criminal court or a civil court. which you can still do now. But what we have done here is we have made it administratively convenient for the purposes of a civil division. We now have a criminal division. So, in other words, the Chief Justice can allocate judges who are still clothed as High Court judges with all of the jurisdiction into any of these administrative paths, if you want to call it that, and can recall them at any time. So I hope that answers that question as best as I could. Tried my best. So, Mr. President, with those few words, I know we are ready to go home early unless somebody else pops up on the other side. I'm very happy to have contributed to this debate. I thank you very much.
Senator Masaisai.
Good afternoon, Mr. President. Good afternoon, my colleagues of this honorable House. I rise to contribute on this bill, the Civil Court Bill. And like my friend Senator Al-Rawi, we on this side, we support the bill. We support the bill. However, I have my concerns as a practitioner in the civil division of the High Court. And I'm happy that Senator Allahar did not avoid that distinction, trying to clarify the distinction with the High Court. It was a concern that I just observed when the papers were given to me yesterday. Certainly we know the bill itself, it defines the civil court as a high court under the definitions of the bill. So it means a high court established under Section 5, exercising jurisdiction in civil matters. And under Section 5 of the bill, it says that upon the commencement of this act, authority and jurisdiction in civil matters exercisable by the High Court shall be exercisable by the civil court. Now, my concern there, and I think Senator Allahar has attempted to address the concern, was that the bill in itself, when it speaks to the High Court, it also has to have an interplay, firstly with our Republican Constitution, which under Section 90 defines the court. Section 90 says, Section 99, it says that there shall be a Supreme Court of Judicature for Trinidad and Tobago consisting of the High Court of Justice, hereinafter referred to, and they put in quotations, the High Court, and a Court of Appeal with such jurisdiction and powers as are conferred on those courts respectively by the Constitution or any other law. Section 100, I think, addresses the situation where Senator Allahar has says that the judges of the High Court shall be the Chief Justice, who shall be ex officio a judge of that court, and such number of Sweeney judges as may be prescribed. And the High Court shall be a superior court of record, save as otherwise provided by Parliament, and shall have all the powers of such a court, including all such powers as are vested in the Supreme Court of Trinidad and Tobago, immediately before the commencement of the Constitution. So I say this in the context of, given that we, in this civil division bill, we are creating a civil court that also has the powers of a high court, we have to look at it in the context of, is it that it is being assimilated with the high court that already exists, or is it a high court that will exist external to the high court that currently exists? That's something that myself as a practitioner, I'm just concerned about. And if that could be a little more defined in the Act in terms of the interplay between the civil high court and the existing high court. I think they should have some sort of clarifications there. Also, with regards to clause 26 of the bill, clause 26 of the bill speaks to the right to appeal. And I believe once the claim is over the prescribed amount of $2,000, it gives you the right to appeal as of right to the Court of Appeal. Now, I heard the Honorable Attorney General indicate that there was a level of consultation, albeit during COVID. My concern is if there was consultation with the current Chief Justice. As we know, the Chief Justice has changed. The office of the Chief Justice, there's a different holder. It is in those circumstances, I think it prudent, because the reports that we have from the judiciary, certainly the ones that we have available to the public, I think the last one is 2020 during COVID as well. So if it is that we are giving citizens this right to appeal to the Court of Appeal, so long as the claim exceeds the amount of $2,000, I think some level of consultation with the appellate courts should, because that, in my respectful opinion, will burden the courts, especially where citizens have that right as of right to appeal. My other point I would like to raise is the issue with regards to the estate of administration. And certainly that is a welcome addition to what currently exists, or a welcome replacement to what currently exists. I observed that there would be a sub-office in Tobago, San Fernando, and in the north. In the north, I presume, would be Port of Spain. I speak on behalf of members of the bar that practice, say, in East Trinidad, that may not have the opportunity to submit their original documents to a sub-office, say, in Sangre Grande, or a sub-office in Arima. Certainly, members who practice in Central Trinidad, a sub-office in Chaguanas may be something that can assist, not just with the practitioners, but certainly with the persons who seek access to justice in regards to administering their deceased relatives' estate. So I'll just say that in that context. And then I would finally like to raise a point that the Judicial Committee has raised with us in the past with regards to when we put laws in place, but not the systems to support the laws. And I am quoting Lord Burroughs from the case of Attorney General of Trinidad and Tobago versus J.M.A. Minor. And at paragraph 29, Lord Burroughs, he basically warns us. He says it was held that their remand was not only unlawful as being in breach of the primary legislation, but was also an infringement of their constitutional rights to the protection of the law under Section 4B of the Republican Constitution. The board referred to the expansive approach that has been taken to the protection of the law provision extended beyond access to the court system in earlier cases such as the Maya Leaders case and the Maharaj versus Prime Minister of Trinidad and Tobago case. Among other facts which the board considered to be relevant in what was stressed to be a fact-sensitive case-specific question, it focused on the fact that the executive had frustrated the legislation by bringing the provisions into force without ensuring that the requisite detention facilities for children were in place, and that this meant that the two claimants were exposed to conditions, environments, and influences which the legislative provisions were designed to avoid. I say this in the context of when we give citizens rights, we can't simply take it back. So when we give citizens the right to bring a claim in the small claims court, it creates that legitimate expectation that they will be given an opportunity to be heard, and an opportunity to be heard in a manner in which Parliament intended. And hearing from Senator Allahar, the intention is for the process to be a little more expeditious than the current process that exists. The intention is that the process to be less expensive than exists, because the small claims court, it would not make sense that the candle costs more than the funeral, for want of a better term. So when we give our citizens these rights, know that they will access it. And if they are unable to access it, we will be held accountable, because we created that constitutional right to a new form of access to justice. So I pray that we have the relevant systems in place, that when this bill is proclaimed as law, that all citizens will be served by it. And I so submit to this honorable court.
The Honorable Attorney General.
Thank you, Mr. President. It's been a very short, unusual debate. It's been unusual because the matter seems to have garnered support from the opposition. It's not unusual that we have support from the independents.
You're taking basket.
If I could begin with my friend, Senator Al-Rawi. Now, there were a couple of things that I didn't quite understand in his contribution, not for the first time. Perhaps I should begin with Senator Masaisai. I take the point that this is a new exercise that the judiciary is embarked upon, and that there will be gaps, geographic gaps, throughout the country, so that for attorneys who practice in the eastern parts of Trinidad, I imagine that the court executive personnel and the Chief Justice himself would probably be following the proceedings, would have taken note of that. And if he has not, I would certainly bring it to his attention. Now I can concentrate on my friend, Senator Al-Rawi. So there are a couple of things that I struggle with. First of all, Senator Al-Rawi, Senator Brown is the curve. He has taken his leave. Thank you. So he said he has no problems with the bill. His difficulties, it seems to me, were grounded in the Hansard. I think he spent 99.9% of his time on the Hansard and very little on de minimis, nothing on the bill. And it seems as if he was preoccupied with the contribution of the Honorable Prime Minister. Now, we have a saying in the law, And I'm sure I would have mentioned it to him when he was my student. Because it's not in every case that you don't have every single, you're not going to win every case. So that there are some cases in which the law is on your side. And in those cases, you tend to speak softly because it's in the bag. So you make technical arguments, you say very little. Now, there are some cases in which the law might not be on your side, but the facts will be on your side.
You found the facts.
So, in those cases, you may speak a little more loudly and you concentrate on the facts. But there are some cases where neither the law nor the facts are on your side.
So you go to the answer.
No. I didn't say that. When that happens, you're in serious trouble. What you do is you pound the table and you make a lot of noise. And that is what my friend opposite was doing. So a lot of it was pounding the table. Now, I just want to carry us back. I know that I just asked for some indulgence here. Last week on the bail amendment, something similar happened. So they came in 2024 to circumscribe Achille Charles because Achille Charles was a problem for the government. It said persons who are accused of murder are entitled to bail. And they came and they tried to ring fence Achille Charles.
Badly.
They failed. Now, what he did then was no different from what he did today. So there was a lot of pounding on the table at the time, and the point was a very straightforward one. We, on this side, recognize that there's a danger of repeat offending as they did, and we did something about it. Now, turning to what is before us today. As I say, he supports the legislation, so he went to Hansa, and he picked on some words of the Prime Minister. Not all, because the Prime Minister spent in that debate in the other place on this bill, she spent a lot of time, the Honorable Prime Minister spent a lot of time talking about unproclaimed legislation. She said there were 18 pieces. I went and I checked. I'll give you page numbers in a while because I have the receipts. She said, listen, you all keep coming to the Parliament, you keep passing law, and you keep putting in a proclamation clause, and then you do nothing. You're wasting our time. Well, that too. So that was a lot. And then she had the presence of mind to itemize it. She said, you did this 18 times. And what's to say you are not going to do it this time? That's what she said. Now, she did make some points, and this is what he nitpicked on, in terms of, okay, well, you have a problem here, you have a problem here with the court executive administrator, and so on and so forth. But at the end of the day, she closed the contribution by saying that she is looking forward to them supporting the bill. I'm sorry, to them actually moving forward with the bill. But then there was a caveat. She said, in the time you have left. Well, history shows they didn't have enough time. Now, just two statements, if I could make, about some comments that my friend made. Now, he said, well, I think this was in respect of him not actually proclaiming the bill. So, just a sec. So, for that he said this, and I wondered if I was hearing correctly. He said, we were attempting to fly the plane while building it. Now, I don't know about you guys, but I am terrified of flying. I'm not jumping in any plane that is being built to go anywhere, right? Because I think that is dangerous, right? And more than dangerous, I think that it would lead to tragedy. And the type of tragedy that led to what took place over there on the 20th of April. Now, he asked another question. What has changed with respect to the staffing matters? Something the Prime Minister raised. Well, my answer to that is that we say we now have a government in place that is more responsible with respect to ensuring that the right bodies are in the right places, even in the judiciary where there have been problems. And I think I know of what I speak. I will not go into details on that this afternoon, but he would know. Now, so that's all that I want to say about my friend. In respect of Senator de Bastide, there were a couple points that were made. One in respect of Section 5, and that's the section that says, upon the commencement of this Act, authority and jurisdiction in civil matters exercisable by the High Court shall be exercisable by the Civil Court. Senator de Bastide, the bill does not, he said, the bill does not seem to provide that the Civil Court is a division of the High Court established under the Supreme Court Adjudicator Act. Rather, it appears that Section 5 is creating a separate High Court. Now, my response to that is this. The definition of civil matter does not include a small claims matter or a state's administration business. So I say there's no ambiguity. The provision is clear where jurisdiction lies. There was a second query as to whether the jurisdiction would only now be exercisable in the civil division or whether it will be exercisable in both the High Court as well as the civil division. And the answer to that is it's a division of the High Court, and as such the authority of the High Court remains. Mr. President, with those words, I beg to move.
Honorable Senators, the question is that a bill entitled an act to make jurisdiction for matters of a civil nature exercisable in a division of the judiciary to be known as a civil division. and to make jurisdiction for specific civil matters exercisable in a subdivision of the civil division known as the civil court, to make jurisdiction for small valued claims exercisable in a subdivision of the civil division to be known as the small claims court, to make jurisdiction for estates administration business exercisable in a subdivision of the civil division known as the Estates Administration Office, and for related matters, be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clerk.
A bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary to be known as the Civil Division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Court, to make jurisdiction for estates administration business exercisable in a subdivision of the Civil Division known as the Estates Administration Office, and for related matters.
The Honorable Attorney General.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Civil Division Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Civil Division Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Attorney General. Are you ready, Attorney General?
Yes, yeah.
Okay.
Clauses 1 to 11.
Well, before you go there, Clerk, I just want to inform members that we have a few amendments circulated by the Attorney General to clauses 12, 20, 22, 22, 32, So it's 12, 20, 21, 22, 23. Right, and 32. And 36. All members have copies? Okay. Yeah, and 36, yeah. Okay, so what we will do is to deal with the first 11 clauses because there are no amendments to the first 11 clauses. Do I have agreement?
Clauses 1 to 11.
The question is that clauses 1 to 11 stand part of the bill. The question is that clauses 1 to 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 11 now stand part of the bill.
Clause 12.
The question is that clause 12 stand part of the bill. Attorney General?
Chair, we propose an amendment in terms of the draft circulated. It replaces Court Executive Administrator with the words Chief Justice. This isn't, I think we hinted at this in the course of our discussions. The Court Executive Administrator is a functionary, a fairly new functionary in the judiciary. The Chief Justice is not. And we think that the position is better stated, the power is better stated as resided in the Chief Justice.
Your devices, otherwise I shall control you. But I don't care. I heard it. I'm saying that control your devices. Okay? Right. Yes, any member? Yes, Senator Faris Al-Rawi.
Thank you, Mr.
Yes.
Chairman. Honorable AG, through the Chairman. So I catch the thought behind it, even though it's perhaps a little bit involved. So clause 12 substitutes in 12(1)(b). The proposal is that the Court Executive Administrator be the person who will do the following: be replaced by Chief Justice, and it would read as follows. So the Civil Court shall, in addition to judicial officers, be staffed with A, public officers, and B, an appropriate number of other persons engaged on contract by the Court Executive Administrator. Could you please consider not only the precedent of the Family and Children Division, where the Court Executive Administrator is placed, and the Criminal Division, where the Court Executive Administrator is placed, but could you perhaps consider, in my view, the Chief Justice would fall into problems if he was inserted here, or the office of the Chief Justice, because the Chief Justice would then be subject to the jurisdiction of the Industrial Court for examination. So when I look at the usual terms that I see in legislation, shall be employed by the government, I go to the Industrial Relations Act, I see that the government is to be the CPO, etc., the administrative arm, with the Court Executive Administrator being cast in law as a permanent secretary functionary responsible for the administrative of arms. In this definition section, it's subject to the Chief Justice. To put the Chief Justice as the employer, I think would cause deep problems for the Chief Justice.
That's a useful point, but the countervailing argument is that the other pieces of legislation have devolved too much power to the Court Executive Administrator. We've had, I think one of your members mentioned it, about a change in the Office of Chief Justice. I will not comment on that at this time, but I think that this formula would be better suited for the new dispensation going forward. And I'd just like to draw your attention to the fact, of course, that the Chief Justice is the chair of the GLSC, and he's sued all the time by aggrieved judicial officers. Granted that this is a wider category of persons.
So AG, thank you so much for the explanation. The caution that I give is not to cause general opposition, but to invite you to consider the ramifications in the wider context. I accept that it's perfectly accurate to say the JLSC has that position in relation to the limited class, that the Constitution gives the JLSC to be the employer in the separation of powers kind of argument.
Not limited, because remember that they basically employ all of my staff.
So by limited, I mean limited to the category in that end for the separation of powers point. So I got that. But to put the Chief Justice in the position of being the actual contracting employer, I urge you to consider it. I understand that I can only make a recommendation, but it's something that perhaps you may want to consider. I know that there is a proclamation clause inside of here. Perhaps when you reflect upon it and do some further consultation, you'd note my concern that I think it's probably headed in the wrong direction. The Executive Court Administrator is defined as subject to the CJ in this Act, and it's also as a creature of cabinet appointment since 1997. It's been clearly defined purely for the administrative functions to do the hiring or firing, PSIP, budgets, etc. But the CJ has the control over the CEA in this law in the definition section.
Nothing else to add, but of course I'll take it under advisement.
Thank you.
All right. The question is, clause 12 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12. The question is that clause 12, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12, as amended, now stands part of the bill.
Clauses 13 to 19.
The question is that clauses 13 to 19 stand part of the bill. The question is that clauses 13 to 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 to 19 now stand part of the bill.
Clause 20.
The question is that clause 20 stand part of the bill. The Honorable Attorney General.
20E, we do not have in our law a creature that is known as the Commissioner of Votes. We have the Commissioner of Affidavits. And B is a suggestion which has been made by our colleagues and with which we agree, that the Chief Justice should have the additional power to designate persons to do this function.
Any, yes,
Thank you.
Senator Faris, Allahar.
AG, in your reflections prior to proclamation, if you could have a look in that space. Relative to clause 20, the use of Commissioner of Oaths was taken in precedent form from the Family and Children Division and the Criminal Division. And when I was scrubbing it at the LRC back in those days, I had looked at the Oaths Act, Chapter 701, and that's where I had felt satisfied that we were dealing with oaths from that capacity. So the other two laws would need to be harmonized if we're going to Commissioner of Affidavits, just to point that out. So if you can have a look at that prior to proclamation. Relative to the Chief Justice or such other person designated by Chief Justice, I have no objections to that.
The question is that clause 20 be amended as circulated by the Honorable Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. Clause 20. The question is, clause 20, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 20, as amended, now stand part of the bill.
Clause 21.
The question is that clause 21 stand part of the bill. Honorable Attorney General.
As before, President, with respect to oaths and affidavits, the explanation is the same.
No, I've noted the concern for the AG to look at prior to proclamation.
The question is that clause 21 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 21 be, the question is that clause 21 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 21 as amended now stand part of the bill.
Clause 22.
The question is that clause 22 stand part of the bill. AG.
There's an amendment. The word fixes placed before assist the magistrate. And that's because in the law, it is slightly ambiguous. So this, we think, and it's not us alone, the judiciary thinks that to make it clear that we should fix the magistrate. And in respect of B, the comment with respect to oaths and affidavits.
All right, the question is that clause 22 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 22 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 23.
The question is that clause 23 stand part of the bill. Attorney General.
Thank you, Chair. The explanation here is as it was before with respect to Court Executive and Chief Justice in clause 12.
Intervention.
Again, just asking AG to have a look at that in light of the other laws prior to proclamation.
Okay. The question is that clause 23 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 20, the question is that clause 23 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 23 as amended now stand part of the bill.
Clauses 24 to 31.
The question is that clauses 24 to 31, to 34, no, to 31 rather, stand part of the bill. The question is that clauses 24 to 31 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 24 to 31 now stand part of the bill.
Clause 32.
The question is that clause 32 stand part of the bill. Attorney General.
Chair, we propose an amendment in terms of the draft circulated. It includes a new paragraph to take into account the reality that these are persons who actually do the work sometimes in the registry.
Any interventions?
As noted before, Mr. Chairman, thank you.
The question is that clause 32 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. The question is that clause 32 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 32 as amended now stand part of the bill.
Clauses 33 to 35.
The question is that clauses 33 to 35 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 33 to 35 now stand part of the bill.
Clause 36.
The question is that clause 36 stand part of the bill. Attorney General?
Thank you, Chair. The rationale is the same as it was in respect of clauses 12 and clauses 23 for replacing Court Executive Administrator with Chief Justice.
Any interventions?
Noted as before. Thanks.
Okay. The question is that clause 36 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no. I think the ayes have it. The question is clause 36 as amended now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 36 as amended now stand part of the bill.
Clauses 37 to 43.
The question is that clauses 37 to 43 stand part of the bill. The question is that clauses 37 to 43 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 37 to 43 now stand part of the bill.
Schedule.
The question is that the schedule now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. The schedule now stands part of the bill. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General. The Honorable Attorney General.
Mr. President, I wish to report that the Civil Division Bill 2026 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on the Civil Division Bill 2026. Those in favor say aye. Those against say no. I think the ayes have it. The Honorable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary to be known as the Civil Division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Court, to make jurisdiction for estates administration business exercisable in a subdivision of the Civil Division known as the Estates Administration Office, and for related matters, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary, to be known as the Civil Division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Courts, to make jurisdiction for estates administration business exercisable in a subdivision of the Civil Division known as the Estates Administration Office, and for related matters, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Division.
Mr. Allahar?
Yes.
Mr. Jeremie, SC?
Yes.
Mr. Roberts?
Yes.
Dr. Swarat Singh?
Yes.
Mr. Maharaj?
Yes.
Mr. Alexander?
Yes.
Mr. Ratiram?
Yes.
Professor Prasad?
Yes.
Dr. Chaitan Maharaj?
Yes.
Ms. Charles?
Yes.
Mr. Zakur?
Yes.
Mr. Smith?
Yes.
Mr. Naked?
Yes.
Mr. Ramsubik?
Yes.
Mr. Rashid?
Yes.
Dr. Brown?
Yes.
Mr. Al-Rawi, SC?
Yes. Do it.
Mrs. Roberts Rajman?
Yes.
Mr. Dhanpaul?
Yes.
Mrs. John Bates?
Yes.
Mr. Hove Masaisai?
Yes.
Mr. Vieira, SC?
Yes.
Dr. Axe?
Yes.
Mr. de la Bastide, SC?
Yes.
Ms. Joan Simmons?
Yes.
Mr. Lewis?
Yes.
Dr. Murray?
Yes.
Mrs. Lalit Etienne?
Yes.
Mr. McNish?
Aye.
Ms. Phillips?
Honorable Senators, the result of the division is as follows. 29 members voted for the bill, no member voted against the bill, and there were no abstentions. The bill has been unanimously approved.
A bill entitled An Act to Make Jurisdiction for Matters of a Civil Nature exercisable in a division of the judiciary to be known as the Civil Division, and to make jurisdiction for specified civil matters exercisable in a subdivision of the Civil Division known as the Civil Court, to make jurisdiction for small valued claims exercisable in a subdivision of the Civil Division to be known as the Small Claims Courts, to make jurisdiction for estates administration business exercisable in a subdivision of the Civil Division known as the Estates Administration Office, and for related matters.
The Honorable Leader of Government Business.
Mr. President, after having had a very productive and pleasant day, I beg to move that the Senate do now adjourn to a date to be fixed.
Honorable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Those against say no. The Senate, well, before I put the adjournment, before I put the final question, may I, on behalf of the Senate and all senators, wish each senator and their respective families a very safe, a very happy, and a very productive Carnival 20. When I say productive, productive means enjoyment. Enjoyment. All right, let me withdraw that word because I could be misinterpreted. A very safe, a very happy, and a very wonderful Carnival 2026. The question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate now stands adjourned to a date to be fixed.